The title of this talk is Constructing a Global Law and the Problem of Perspective. This is a paper and talk I gave at the University of Aix-Marseille in France in 2014. The University at Aix-Marseille is one of the most important centers for legal study in Europe. It was at a comparative law conference sponsored by Juris Diversitas. The essays and papers delivered at that conference were later published in this form by the University of Aix-Marseille, and the editor of this volume was Olivier Moreau. I'm going to read just the introduction for my talk as it lays out a particular topic. The problem of perspective. One difficulty in the project of building a regimen of global governance is that of maintaining perspective on the work involved. The project, after all, is global in its extensiveness and ubiquitous in its influence. It offers no completely detached vantage place for purposes of evaluation and reflection. In no aspect of the program of global consolidation is this problem of perspective more critical than that of assembling a uniform and consistent regimen of law. For those jurists, statesmen, and academics who work to establish a legal mechanism around the world, the matter of perspective is fundamental. It could be said that for those leaders, it is their single greatest challenge, their great problematique in constructing a durable and effectual structure of global order. The limitation is especially acute as affairs of the world are being reshaped under the aegis of a single hegemonic power. At that time, it was the United States. It also takes on a special significance when the question of perspective involves the inner workings of Anglophone law. Of the two great forms of Western legality, European, civil, English common, each has embarked upon its own creative program of adaptation in an era of tumultuous global change. Practitioners of the European method have opened new ground by applying their technique to organize the first real postmodern aggregation of states, that is, the European Union. At the same time, practitioners of the English method have achieved an undeniable ascendancy as they seek to construct an enveloping regime of economy, communication, and political compliance around the world. This is best represented by what's called the liberal international rule-based order. Both of these forms of law being applied on a global scale are, of course, derivatives of a single tradition that originated in the West centuries ago. In fact, one of the best ways to gain an objective view on either one of them is to examine its unique features in relation to that of the other. This approach can be especially useful in evaluating the practices employed and progress made as they both work toward the end of global unity today. They can also be compared and contrasted in their parallel development over centuries in the past, examining their nascent beginnings when both existed in their most basic essentials can be highly illuminating. This approach is particularly useful, for example, when examining the impact of technology on matters of law and governance, a central factor in the process of globalization occurring today. In conclusion, as the two Western traditions of law converge to create a global regimen of order, The hope and expectation is that such an order will combine the best attributes of both. That is, the principled predictability of the civil or continental law and the malleable adaptability of the common or Anglophone law. But the question remains, is there an adequate perspective from which to evaluate the result?